Partnership. What are you aware about this chapter, the Indian Partnership Act? Have you heard about it earlier in your accountancy?
Ma'am, two or more persons jointly do the business, ma'am.
Jointly do the business. And they jointly do the business for what? Like, what is the aim of doing that business?
Profits.
Yes, the motive is mostly profit. They come together to earn the profit. Now, if two or more people want to do the business and they are related people, like they are the family members, can they not do Hindu undivided family? Like they can't get registered under HUF? In partners, is it important that they are brothers or they are related people in one family?
No, ma'am.
No, partners can be any two people, two friends also can become partners, right? Now, let's see what they have given over here. General nature of partnership is your unit 1, and we'll be discussing what is partnership, essential elements of a partnership, how we can verify that okay, this is actually a partnership and not an HUF, because that's why I asked you, if two family members are there and they come together, can they also do a partnership, or they can form an HUF? So that is what we have to see. How partnership is different from joint stock company, it is different from the club organization, then how it is different from HUF, and how it is different from co-ownership and association. That also we are going to cover in this unit. Along with this, we'll see different types of partners, active partner, sleeping partner, then dormant partners, all these things we'll be seeing over. Okay. First, let's see what is the definition given of partnership, partner, firm, and firm name as per section 4 of the Indian Partnership Act. So partnership is the relation between persons who have agreed to share the profit. They're doing the business for the profit purpose, and they have agreed to do the business, and they have decided that they will be sharing the profit of the business, carried on by all or any of them acting for all. Now A, B and C are partner, but A has only invested money, right? He has only invested money. He's not going to act as a working partner. He's not going to do all the chores of the business, etc. He's just going to be investing the money, right? So in that case, you can say this person is not going to act. And also, if we say B is also not going to act, he's also investing the money, right? He's also just investing the money. So C is going to act on behalf of all. Any of them acting for all. Any of them will be acting on behalf of everyone, right? Person who have entered into partnership with one another are called individually partners. People who get come together and enter into a partnership are called as partners. Individually, they are called as partners, and collectively a firm. Collectively, you call this association as partnership firm. And the name under which the business is carried. Now, partner's name is different, and the business name is different. The name of the business is called as firm name. Okay, is this clear to you all? Like definition of partnership, partner, firm, and firm name. There are 5 people in the meeting and no one is answering. Okay, thumbs up is there. Okay, I have to keep this window with me. Elements of partnership. I'm taking it a little fast because I think you have covered this earlier in your accountancy. So I'm just considering that you are aware of the terms. Okay, let's go ahead. Elements of partnership. Definition of partnership contains the following 5 elements which must coexist before a partnership can come into existence. So in your definition of partnership, what we have seen, relation between persons who have agreed to share the profit of a business carried on by all and any or any of them acting for all. So this definition has 5 elements which must coexist. They all should be existing together, and before the partnership can come into existence, all this should be existing together. Let's see what are these elements. Partnership is an association of two or more persons. So if you want to start a partnership, you need two or more people for that partnership. It should be a result of an agreement entered into by all person concerned. So all these people concerned should enter into an agreement. Then partnership is organized to carry on some business. You are going to do some business. Let's suppose they are going to do footwear sale business, right? They are going to do shoes manufacturing or footwear sale business, footwear trading businesses there. Agreement must be to share the profit of business. These three people are going to share the profit. What is the PSR thing? You know, profit sharing ratio?
Yes, ma'am.
Okay. So let's suppose they are going to share 1:1:1 ratio. So that is their PSR. Business must be carried on by all or any of them acting for all. Either A and B will conduct the business, or B and C will conduct, or any one's individual can also conduct the business on behalf of all. Right? This is how we have broken the definition. Let's discuss each of the element in detail now. Partnership is an association of two or more persons. Again, only persons recognized by law can enter into agreement of partnership. Recognized by law means you should be a major and of sound mind. Right? These are the two criteria recognized by law. Person recognized by law. Therefore, a firm, since it is not a person recognized in the eyes of law, cannot be partner. Now, in your partnership, a person should be recognized by law. Firm cannot be a major, firm cannot have its sound mind. So that is why a firm cannot be a partner. Again, a minor cannot be a partner in a firm, but with consent of all the partners may be admitted for the benefits of partnership. Now, what they have said is a minor cannot be a partner, but there are few exceptions. Your minor can be partner only for profits, and he can be admitted only after approval of all partners, right? Only when all the partners have approved, then only that minor can become a partner, and this minor will be only sharing the profits. He won't share any of the losses. If the profit is there, give partner the profit, minor partner the profit, or else if loss is there, do not give the share of loss to the minor partner. Partnership Act is silent about the maximum number of partners, but Section 464 of the Companies Act 2013 now has put a limit of 50 partners in any association or partnership firm. So for any partnership firm, maximum number of partners that can be there is 50. Okay. Is the first point clear to you all?
Yes, ma'am.
Okay, let's go ahead. Agreement. It may be observed that partnership must be result of an agreement. Agreement is to be done for a partnership, because tomorrow if any partner denies, no, this is not my loss and this is not my profit sharing ratio, that time we need a basis, we need a proof. That is why it is observed partnership must be result of an agreement between two or more persons. There must be an agreement entered into it by all the person concerned. So if there are four partners, all these people have to give the concern, and all these have to come together to agree in that agreement. This element relates to voluntary contractual nature of partnership. Now people get into a voluntary partnership when four people voluntarily decide from today we are going to start selling dupes of Nike shoes. So that is where they are coming together voluntarily. No one, government has not asked them to come together. They are voluntarily coming and making a contract in the nature of partnership. Thus, the nature of partnership is voluntary and contractual. Partnership is having the nature of voluntary and contractual. No one tells you to get into partnership, like no one forces you by the law, etc. But you voluntarily come into a partnership business, and it is contractual. It is based on an agreement contract. An agreement from which relationship of partnership arises may be expressed. It may also be implied from the act done by partners and from a consistent course of conduct being followed, showing mutual understanding between them. Agreement of this relationship may arise as an expressed agreement. You have to write down this agreement, or you have to orally say that this agreement has been entered. You cannot just consider it as implied. But in such cases where the partners are acting in a manner that it specifies, okay, we are impliedly doing things. Yes, we are partners of this particular firm. That time you have to mention that partner's name in the agreement also. Okay. So that is where implied follows. Like by the conduct of that person, he is behaving as if he is the partner of the firm. So that is where you can consider that this partnership has come into existence. From a consistent course of conduct being followed, showing mutual understanding between them. It may be oral or in writing. Your partnership act can be partnership agreement can be in oral or in writing, but preferably everyone exercises the writing agreement. They make a partnership deed so as to protect the interest of the partners and the partnership firm. This point is clear.
Yes, ma'am.
Let's go ahead. Business. In this context, we will consider two propositions. First, there must exist a business. So for a partnership, why they are getting into a partnership? Because they want to earn profits, and you can earn the profits from a successful business. So a business should be in existence. For the term business includes every trade, occupation and profession. Two doctors also can come together and enter into a partnership. That is also a professional business, right? Any trade, any occupation or profession. Teaching, me and Sudarshan have got into a partnership. So that is a business that we are doing, right? The existence of a business is essential. Secondly, the motive of the business is acquisition of gains. Acquisition of gain means to get the profit, which leads to formation of partnership. So formation of partnership happens when a business is to be run and the motive of that business is to gain the profits. That time a partnership is created. Therefore, there can be no partnership where there is no intention to carry on the business and to share the profit thereof. If you don't have the intention of carrying on the business or not to share the profit, a partnership cannot come into existence. What they have given over here, existence of business and acquisition of gains. These are two important elements for a partnership. Next is your agreement to share profits. Proximity error at this point. Okay, the sharing of profits is an essential feature of partnerships. So no one will come together with you for money, charity purpose. They'll come together with you in a partnership because they want to earn the money. There can be no partnership where only one of the partners is entitled to whole of the profits of the business. If only A is getting all the profit, B won't get into a partnership agreement. Partners must agree to share the profit in any manner they choose. They can decide in the ratio 1:1, 2:4, 3:7, any ratio they want, they can decide. But an agreement to share losses is not an essential element. So in the essential elements, it's not compulsory that they agree to share the losses. Whenever we make the agreement, we always write that we agree to share the profits, because it is considered that partnership business is done only to share the profit. Business is done to share the profit. That's why agreement to profit is considered, but not agreement to loss. It is open to one or more partners to agree the share of losses. However, in the event of losses, unless agreed, okay, this text has been cut. Give me 1 second. Yes. So, however, in the event of loss, unless agreed, otherwise, there must be born in the profit sharing ratio. So you have to agree with the partners in the profit sharing ratio. Unless it is written in your agreement that we are going to agree on the losses also, you are always going to write in your partnership deed agreement to share profits. Eventually you are going to share the losses also. Still, you have to mention in the wordings profit sharing ratio. We don't write loss sharing ratio. We write it as profit sharing ratio. And the losses also will be distributed in that profit sharing ratio. Okay. Is this point clear?
Yes, ma'am.
Let's go ahead. Let's see some examples that they have given. Co-owners who share amongst themselves the rent derived from a piece of land are not partners because they do not exist. There does not exist any business. Now, this is a piece of land. This is owned by Mr. A and B, right? Here, they have not entered into a partnership agreement and there is no business. They are just getting the rent from a land. They don't have this business of giving on rent multiple lands. They have one land and they are getting the rent. So, this is not going to be covered under your business thing. Okay. Then we have no charitable institution or club may be floated in a partnership. Any charitable institution, your school, college is there, or a club is there for the benefit of its members. This will not be floated in partnership. We have heard about the social club, etc. So these won't be partnership. A joint stock company may, however, be floated for non-economic purposes. If a joint stock company wants to do something for the society, they don't want the profit out of the business. What they can do is they can get into or they can enter into a partnership business. X and Y buy certain bales of cotton which they agree to sell on their joint account and to share the profits equally. In these circumstances, X and Y are partners in respect of such cotton business. X and Y enter into a cotton business. They said that we'll be acquiring these bales of cotton and we will be selling them together. So now these two will be acting as the partners for your cotton business. Okay. Are the examples clear?
Yes, ma'am.
Okay. Business carried on by all or any of them acting for all. Now, your business may be carried on by all the partners together, or only one partner will be acting on behalf of everyone. Right? A, X, Y, and Z. All these are partners, but only Y is doing the whole work of the partnership. He is the only person who is selling the footwears at the shop. So he is the active partner. Business must be carried on by all the partners or by any one or more of the partners acting for all. So, only one person may act or everyone will be doing the work. This is the cardinal principle of the partnership law. This is the important principle of partnership law, that any one person will be doing the business or all of them can do the business for the firm. In other words, there should be a binding contract of mutual agency between the partners. Now, here, all these partners A, X, Y, and Z should agree that only Y is going to do the business. Only Y is going to see the major working activities, major operations are going to be handled. So, a mutual agency should be there, mutual agreement should be there between the partners. An act of one partner in the course of business of the firm is in fact an act of all the partners. If one activity is done by Y, it will be considered that their firm AXYZ has done that activity. All the partners have done that activity. One person is going to represent the entire firm and all the partners. Each partner carrying on the business is the principal as well as the agent for all the partners. Now, if Y is acting as the person who is going to be a working partner, he is going to be the agent for this entire firm and entire partners A, X, Y, and Z. Right? They will be acting in the principal agent relationship. We have seen the agency contract, and there we learned that partner is the agent of the partnership firm. He is an agent insofar as he can bind the other partners by his act, and he is principal to the extent that he is bound by the act of other partners. Now, in this situation, for A, Y is the agent. For X, Y is the agent. For Z, Y is the agent. But when it comes to Y, like if other person are doing the work, if we say A is going to take the task, he is going to be the working partner. then Y will become here as the principal. Even though he is agent for others, A is also working partner. So here Y will become principal. Okay, that is where his acts are bound by other people. Like if whatever activity is done by Y, other people have to agree with it. And if A is doing some activities, other people X, Y, Z also have to agree with it. And it is bounding on all of them. It is binding on all the X, Y, Z members. It may be noted that the true test of partnership is mutual agency. How clearly they are agreeing with each other, how well their mutual agreement is there, is the true test of partnership, is where you can see that this partnership is actually into existence. Rather than sharing of profits. If two people are sharing the profit, that does not mean it is partnership. If they mutually agree by an agreement, then you can say that this particular formation is of a partnership business. If the element of mutual agency is absent, there will be no partnership. If there is no mutual agreement, one is agreeing on selling the footwear for the men's section, one is agreeing on selling the footwear for the women's section. So this is completely different thoughts. There you can't say that they have a partnership because they are not mutually agreeing on one thing. Let's see the example. A, B, and C are partners in ABC Associates, a partnership firm. If A made certain purchases for the business from Mr. K, then Mr. K can recover the money from A, B, or C, as all the partners are liable for the act done on the behalf of firm. Now here we can see A, B, and C are partners in partnership firm. If A made certain purchases, if one of the partners is making certain purchases, entire partners will be liable to pay for that purchases. If one is making the purchase, others will also have to compensate for it. The business will have to pay for it. Okay. Till here, all these 5 concepts are clear to you people.
Yes, ma'am.
Thumbs up is there from few people. Only 3 have answered. Now, let's see, they have given us a case scenario. They've given us a case law. In KD Kamath and Company, Supreme Court has held that the two essential conditions to be satisfied are there should be an agreement to share the profits. In this case law, what happened is when partnership will be recognized, when they have agreement to share the profit as well as losses of the business. So partners will be sharing the profits and losses of the business, must be carried on by all or any of them acting for all within the definition of partnership under section 4. They should be carrying on the work together, or any one of them should be carrying on the work on behalf of all the partners. So first important point as per this essential elements in the KD Kamath and Company case law is they should be agreeing to share the profits as well as losses of the business. Next is business must be carried on by all or any of them acting for all within the meaning of the definition of partnership. As mentioned in the partnership definition, all of them should be carrying on the business or only one can act as the entire, like any one of them can act for all the partners. The fact that exclusive power and control by agreement of the parties is vested in one partner or further circumstances that only one partner can operate the bank accounts or borrow on behalf of the firm are not destructive of the theory of partnership, provided the two essential conditions mentioned earlier are satisfied. Now, if they have agreed that only one partner will be operating the bank account of the firm, so that is also okay, not an issue in that. If one of them can only sign it, then it is okay and the partnership firm can go ahead. The partnership agreement is also known as partnership deed. We have learned this in accounts that partnership deed is prepared. Okay, let's see the true test of partnership. Mode of determining existence of partnership, section 6. In determining whether a group of persons is or is not a firm, whether a person is or is not a partner, regard shall be had to the real relation between the parties as shown by all relevant facts taken together. So if a group of people are there, is it a partnership or not? We'll have to check. If two people are claiming that we are partners of ABC and company, so we have to check, are they actually partners? We will check this by seeing the real relation. Real relation between the parties as shown by all the relevant facts taken together. So whatsoever supporting documents they are giving us, from that we'll be checking, is it actually a partnership business or not? For determining the existence of partnership, it must be proved. There was an agreement between all the partners concerned. So we have to see if there was an agreement between all the partners concerned. ABC and company. So all the partners A, B and C have an agreement made where all of them have given their approval. Agreement was to share the profits of the business. Agreement should contain that they are going to share the profits of the business. Business was carried on by all or any of them acting for all. Same points they have repeated again, that there should be an agreement to share the profits. It should be carried on by all or any of them acting for all. Okay. Again, they have mentioned the same thing over here. Let's just go through it. Partnership is created by agreement and not by status. Section 5. You can't agree that we are partners from today by status. You have to enter into an agreement. This is an important aspect. The relation of partnership firm arises from contract and not from status. And in particular, the members of a Hindu undivided family carrying on a family business as such, or a Burmese Buddhist husband and a wife carrying on a business as such, are not partners in such business. So, members of a Hindu undivided family and the husband and wife in the Burmese Buddhist, what they say is they can run the business together. So, if they are carrying on a business together, still they cannot be considered as partners of the business. They'll be considered under HUF business. Sharing of profit. The sharing of profit or gross returns arising from property by persons holding a joint or common interest in that property does not itself make such persons partners. So I told you that there is a land which is A and B are the co-owners of it, right? A and B are the co-owners. They are getting the rent from the land. So if they are getting any value from the land, that is returns from the land, they can't be said to be partners until they have an agreement and they're doing a business. This land is owned by two people. They are not carrying on the business. They are just doing it for earning the rent out of that business, earning the rent out of that land. There is no business involved over here. The receipt by a person of a share of profit of a business or a payment contingent upon the earning of profits or varying with the profits earned by a business does not itself make him a partner with the person carrying on the business. And in particular, the receipt of such share of payment by a lender of money to person engaged or about to engage in a business, by a servant or agent as a remuneration, by a widow or child of the deceased partner as annuity, or by the previous owner or part owner of the business as consideration for sale of the goodwill or share thereof, does not of itself make the receiver a partner with person carrying on the business. Now, if some lender of the money, now you enter to take loan from the bank, or someone in the business gives you a loan. So you can't say that when you're giving a loan that this person is my partner. Or if you are giving some remuneration to the servant, you are giving some salary to the servant or agent, you can't say that agent is your partner. If you are giving some money on the death of a deceased partner, if A, B and C were partners, A, B and C were partners, and C dies, you give some money as annuity, like at the end of the life of that partner or at the death of the partner, or at the end of term of the partnership, you give some money to Mrs. C. Now, Mrs. C won't be the partner. She's just getting the benefits of the partnership firm, which was her husband's share. She's not becoming a partner over here. By a previous owner or part owner of the business as consideration for the sale of goodwill or share thereof does not of itself make the receiver a partner with the person carrying on the business. Now what happens is, this is A, B, C, and they have their A, B, C and company business. Now they acquired, you know that acquisition thing, have you learned in accounts? Have you learned about acquisition thing in accounts? I hope I'm not talking to the walls over here in my room. I'm talking to people in the meeting. Okay, you don't have the idea about acquisition. One has answered. Two have answered. Okay, let's consider now. No one knows. Now, you know about the merger of Flipkart and Myntra. Like Flipkart had acquired Myntra. Have you heard about this? HDFC Bank acquired HDFC Limited. Have you heard that? Array, at least unmute yourself and say. Yeah, so some of you have heard. Now, if a person, you know goodwill, right? Goodwill, you are aware?
Yes, ma'am.
So when does
Yes, ma'am.
goodwill arise? When does goodwill arise? I need an answer. You have to, okay, reputation is your goodwill. What else? When does a goodwill arise other than reputation? You might have learnt in your accounts. Good name, goodwill, and etc. is okay. Other than that, purchase of a business. Correct. That's what I wanted. Only one girl is interested to study. Others are just listening the lecture and are gonna go away. Right? They don't want to score. Now, I told you these are the partners of ABC and company. These three people are partners of ABC and company. And AB and company. These two partners, A and B, were also in another business of their own partnership. Now they are merged over here. Now they are acquired over here. Sale of business has happened. So when you sell a business, the goodwill, the reputation is taken over. Right? Now let's suppose rather than AB, we can take two cricketers example. Virat and MS Dhoni. These are two partners, right? Now they come in a partnership business. They were already in a partnership business. Now they join with Rohit Sharma, right? Now these three people have come into partnership. When Virat and MS name gets joined with the name of Rohit Sharma, these two are very good players and they have a good reputation. Now they are selling their business. They are getting merged into another business. That time when they are selling the goodwill, you have to give them some worth. You have to give them some money, right? So if you are giving some money, if Rohit Sharma is paying some money to Virat and MS Dhoni, that goodwill amount won't make AB and company the partner of this firm. Right? This is an individual firm. This is another firm. If you are giving money to AB and company, the firm, then that will not become your partner. But Virat and MS Dhoni are joining you in the entire business. They will become your partner. The firm will not become a partner. AB and company will not become partner. A individually will become partner. B individually will become partner. Okay. Is this point clear?
Yes, ma'am.
Yes.
As discussed earlier, sharing of profit is an essential element to constitute a partnership. So you have to see that for a partnership business, it is important that the partners are sharing the profit. But it is only a prima facie evidence and not conclusive evidence. We can just see it by the name of it or by the appearance of this partnership firm that they are going to share the profit. In that regard, the sharing of profits or of gross return acquiring from property by persons holding joint or common interest in the property would not itself make such persons partners. The example that we took over here of this land example is again repeated. Although the right to participate in profit is a strong test of partnership, and there may be cases where upon a simple participation in profits, there is a partnership, yet whether the relation does or does not exist must depend on the whole contract between the parties. If they are coming together and agreeing that we will be acting as a partner, that time only you can say that they are getting into a partnership and they are running some business. Only you have a piece of land and two people are getting the rent, A and B, that is not where there will be partnership. They are not into the business of giving the land on rent. If they are into business of giving land on rent, then they will be considered as partners. Okay, let's see what's ahead. Now, in the exam, if they ask you, you have to just mention these 3 points. This explanation is always repeating itself. This explanation, like two people won't be partners if they are having the common interest, etc. This is just the repetition of what we have learned earlier. Where there is an express agreement between partners to share the profit of a business and the business is being carried on by all or any of them acting for all, there will be no difficulty in the light of provisions of section 4 in determining the existence of or otherwise of partnership. So they have just repeated the definition over here, that if there is an expressed agreement, a written or an oral agreement between the partners, then you can't say that they are into other business. They are definitely into the partnership business because they are agreeing to carry on the business, and they are agreeing to share the profits of the business. Why did it become blank now? Give me 1 second. But the task becomes difficult when either there is no specific agreement or the agreement in such or as does not specifically speak of partnership. In such a case, for testing the existence or otherwise of partnership relations, section 6 has to be referred. And as per section 6, regard must be held that the real relation between the parties, as shown by all relevant facts taken together, the rule is easily stated and is clear, but its application is difficult. Cumulative effect of all relevant facts, such as written or verbal agreement, real intention and conduct of the parties, other surrounding circumstances, are to be considered while deciding the relationship between parties and ascertaining the existence of partnership. Now, when it becomes difficult, when there is no specific agreement written that now from today we are going to act as partners, or it does not speak anything about partnership, that time you have to check that if there is partnership or not, we have to refer section number 6. Now, in section number 6, what happens is real relation is to be tested. Are these the brothers? They are running a business. If they are the brothers of the same family, then that is HF. If it is husband and wife who are running the business, that is again an HF. You can't say that this is a partnership business. So the rule is we have to see that if nothing is clearly given in the agreement, you have to see how they are applying the business, how they are running that business. Then cumulative effect of all the situations you have to see, is there only oral agreement or they have only verbal agreement or it is a written agreement, that is to be checked. What is the intention of getting into the business, why they are doing these transactions, what are other situations making it look like a partnership firm. And after understanding the relation between the parties and seeing the situation, you will judge that is it a partnership or not. See, majorly I will tell you these points are not which they'll be asking you. You just need to remember three things. The agreement should be there, sharing of profits should be there, and they should be having a mutual agency. These major keywords that are given over here, you have to mention this entire paragraph when you write your answer, when they ask you about how we have to check the true test of partnership. Then you have to mention sharing of profit, and you have to mention these cases where it is not a partnership. These four cases which I explained you, the lender of money, servant of agent, widow, and the goodwill case, that you have to mention. And then you have to go forward to your agency business, existence of mutual agents, right? These are three major points you will be mentioning when it comes to true test of partnership. Clear, everyone?
Yes, ma'am.
Okay, let's go ahead. Okay, 1 second. I will get to partnership here. So now we'll come to the third point, that is agent. Existence of a mutual agency, which is the cardinal principle of the partnership law, is very much helpful in reaching a conclusion in this regard. So if you want to test if the business is of partnership, you have to see that is there a mutual agreement, is there a mutual agency between them. Each partner carrying on the business is the principal as well as agent of other partners. We have seen this. So the act of one partner done on behalf of the firm binds all the partners. If A is buying some goods on behalf of A, B, C and company, so it is going to be binding on all the partners and the partnership firm. If the elements of mutual agency relationship exist between parties consisting a group formed with a view to earn profits by running a business, a partnership may deem to exist. So a group of people are coming and their relationship is that they are going to run a business to earn the profit. That time you can say a partnership is existing. Existence of mutual agency, which is the cardinal principle of partnership law, is very helpful in reaching the conclusion in this regard. I guess this paragraph has been repeated. It has been repeated. Santi Ranjan Das Gupta versus Das Ryan Murzamul Supreme Court case law says that following factors weighed upon the Supreme Court to reach the conclusion there is no partnership between the parties. So in these particular cases, there will be no partnership between the parties. What are these cases? Parties have not retained any record of terms and conditions of partnership. So if you're making a partnership deed, you have to mention the terms and conditions. If there's no terms and conditions, you can't say that it is a partnership business. Partnership business has maintained no accounts of its own, which could be open to inspect by both the parties. If there are two partners in it, A and B, they need to prepare their books of accounts for the firm, A, B and company, right? They need to prepare their books of accounts for the firm. If there is no books of accounts of the firm, not the partners, of the firm, then you can't say that there is partnership. No account of the partnership was opened in with any bank. So if you are running a partnership business, it is your duty to open a bank account for the partnership firm. No written intimation was conveyed to the Deputy Director of Procurement with respect to newly created partnership. So if you are newly creating a partnership, you have to file the partnership deed with the Deputy Director of Procurement. You have to file a partnership deed. You have to file it online with this Deputy Director of Procurement. You have to give them a written intimation that we are starting a partnership firm. Okay, are these 3 points clear? Agency, your agreement, and sharing of the profits. These are the 3 points which will help you to truly test the partnership business. Now, when they ask you agency business, you have to write this one paragraph and this case law points. Even if you don't remember the case law, it's okay. You have to just write there is no partnership when there is no record of terms and conditions of partnership, when they have not maintained the books of accounts of the partnership firm open to inspection by both the parties, no account has been opened in the bank in the name of partnership firm, and third is if you have not conveyed it to the Deputy Director of Procurement. If you can't remember the fourth point, first 3 points are very simple. Need a partnership deed written, terms and conditions should be written. Second is books of accounts should be maintained. Third is there should be a bank account of the partnership firm. These 3 points also, if you remember, that will help you to write this answer. Okay? Clear, everyone? Are we clear till here?
Yes, ma'am.
Yes.
Okay. How many have left? Okay. 3 of them have left. Fine. Partnership distinguished from other form of organization. Now, how partnership is different from other businesses, we'll be checking that. Basis is partnership and joint stock company. First, we'll be seeing that. Company, as we have already learned in accounts, is a separate legal entity distinct from its members. And a firm is not a legal entity. Firm is not a legal entity. That is, it has no legal personality distinct from the personality of constituent members. Partnership firm, the name itself says that partners are making that firm work. So they do not have a separate legal entity, and the partners are the identity of that firm. Here in joint stock company, company acts as a separate person distinct from its members. In a firm, every partner is an agent of the other partners as well as the firm. And in a company business, a member is not an agent of the other members of the company. His actions do not bind the others. The actions done by the members or the shareholders, like we can also invest in a company, but we are not the agents of the company. We are just the shareholders. We are just the members of it. Distribution of profit. The profits of the firm must be distributed among the partners according to the terms of partnership deed. We have to distribute the profits as per the partnership deed PSR ratio that they have mentioned. But in the company, if you have the profits, if you have enough money, then you give it to shareholders. You don't have to compulsorily distribute. There is no such compulsion to distribute its profit among its members. Some portion of profits, but generally not the entire profit, become distributable. This is dividend. You have heard this word dividend?
Yes,
ma'am.
ma'am.
Yeah. So among the shareholders, only when dividends are declared, only when dividends are given, that time only shareholders get the money. Or else what option they have? They can sell the share and get the money, right? That is how two profits are there of a shareholder of a company. Dividend is one profit, other is the gain on sale of share. Now, going ahead. Extent of liability. In a partnership, the liability of the partners is unlimited. If the money is exhausted, you have to pay 10 CR and the firm has only 7 CR. So the remaining 3 CR will be paid by the partners A and B. Their liability is unlimited. They have to sell their house or etc. They have to bring the money from their house. This means that each partner is liable for debts of a firm incurred in the course of the business of the firm, and these debts can be recovered from his private property. He can sell his house and give the money. This money can be recovered from his private property. If the joint estate is insufficient to meet them wholly, if the joint estate, the firm's business money is insufficient, this 7 crore is insufficient because our liability is 10 crore. Right, so this is insufficient. 3 crore will be brought by partner A and B. When it comes to company, the liability is limited by shares. If you have 10 shares, your liability is only to that extent. Sorry. Was wrong with this one. So, in the partnership business, in the company business, the liability is limited by shares. If you have 10 shares and they are for rupees 100, and if the firm is not, if the company is not able to pay, you only have to give rupees 1000. That is your maximum liability, not more than that. Liability of shareholders is limited to the amount, if any, unpaid on his share. But in case of guarantee company, the liability is limited to the amount for which he has agreed to be liable. However, there may be companies where liability of members is unlimited. Now, basically what happens is, if a company is there, two cases will be there, and in some circumstances there will be third case. So in normal companies, what happens, if the share price was rupees 100 and you have paid only 77, so the remaining 23 rupees that you have unpaid is your liability. You are limited by that liability. Limited liability. Right. Now, if some shares are of rupees 100 and they are completely unpaid, in the guarantee, if a company has given a guarantee of the other company or the business of the company, then that time liability will be amount of guarantee. Amount of guarantee. If I am giving guarantee of a business of a company who is earning 10 CR and I give a guarantee of 2 CR. So my liability will be the amount of guarantee I have given, rupees 2 CR. Because I said if they don't pay, if the company does not pay, I will pay 2 CR. So that is where the guarantee companies work. Liability is limited to the amount agreed to be liable. I have agreed I'll be liable for 2 CR, then I am going to pay only 2 CR. Then the third case is where the liability will be unlimited. Unlimited. Now, this may happen where the company is becoming insolvent, where the company is becoming bankrupt, or there is fraud involved in the company. That time, the liability of members will be unlimited. Have you heard about that Vijay Mallya case?
Yes, ma'am.
Yeah. So in that case, his liability is unlimited. He has to pay the entire money that he has done a fraud. His company has done a fraud by his individual means. He has to sell off his house, etc., and give the money. Firm's property is that which is the joint estate of all partners, as distinguished from the separate estate of any of them, and it does not belong to a body distinct in law from its members. Now, here what happens is, this property, if the firm owns an office, right? The firm owns an office. This office will be like the property of all the partners. It is not the property of one partner. And the office of an individual partner, if A is the partner over here, so A has his separate office, right? So this and this office cannot be clubbed. This is the firm's office. So it is going to be the partnership firm's office. All the partners have right. But B, C, and D, they don't have the right over here, right? They just have the right in the office of partnership. In a company, its property is separate from that of its members, who can receive it back only in the form of dividend or refund of capital. Now, in the company, the property of the firm is company is different, and members' property is what, how much they have invested. If the amount that has been invested is rupees 77, so this is the property of the members. If they get the dividend, that will be the property of the members. And if the capital is refunded, money is given back to the shareholders, that is what is their property over here. Transfer of shares. A share in a partnership cannot be transferred without the consent of all the partners. You have to take approval of all the partners to transfer your share. But in case of company, a shareholder may transfer his shares subject to provisions contained in articles. Now, what happens is we usually see the share price of Tata Motors has increased, Tata Communication has increased. Now we can sell it. So now do we go to company and ask for permission? No, it is written in the articles of the company. The shareholders can sell the firm's share anytime they want. Okay. In case of public listed companies whose shares are quoted on the stock exchange, the transfer is usually unrestricted. In public limited companies, the companies which are open for the public to subscribe, that time you can unrestrictedly, you don't have to take anyone's permission, you can sell it anytime. Okay, let's go ahead. Now, management. In the absence of an express agreement to the contrary, all the partners are entitled to participate in management. If it is written in the partnership deed, only A will be the managing person, then A will manage. Otherwise, in absence of written express agreement, that time all the partners can become the managers of that business. Members of the company are not entitled to take part in the management unless they are appointed as directors. I am the owner, or like you can say I am the member of Tata Motors. I have a share of Tata Motors. I only have one share. Can I become the member of the company? Can I be entitled to do the management decisions? No, because I only have one share. People who have huge shares or who are appointed as directors will become the management of that company, in which case they may participate. So if someone is the director of that company, someone is the key managerial person of that company, is the CFO of that company, they only can become the management members of that company. Members, however, enjoy the right of attending annual general meeting, and voting, where they can decide certain questions such as election of directors, appointment of auditors, etc. Members can attend the annual general meeting and they can decide that who will become the director. Can we appoint a new auditor? All these things we can a member can do in the annual general meeting. Now, in this registration, for a partnership, registration is not compulsory. And when it comes to company cannot come into existence unless registered under the Companies Act 2013. Unless your company is registered under the Companies Act 2013, it will not come into existence. Winding up, a partnership firm can be dissolved at any time if all the partners agree. If all the partners are agreeing, that time you can dissolve the partnership. And in the company, a company being a legal person is either wind up by National Company Law Tribunal (NCLT), or its name is struck off by the Registrar of Companies. When NCLT, National Company Law Tribunal, winds up the company, it gives the order, now this company has to be wound up. He had the company, Vijay Mallya had the company Kingfisher Airlines, if I'm not wrong. So NCLT issued that this company should be wound up. That time they started winding up that company. Or if the name is struck from the registrar of company erases your name, cuts off your name, that time you can say that you can wind up the company. Number of number of partners, you can just say. Section 464 of Companies Act, the number of partners in an association shall not exceed 100. Now, as per Section 464, this number of partners cannot exceed 100. However, the rule given under the company's miscellaneous rule restricts the present limit to 50. So presently the limit is 50, but it can be extended to 100 by the change in the rules of companies. But now, for now, you need to remember 50 is the limit. A private company may have as many as 200 members, but not less than 2. Private company can have maximum 200 members and minimum, that is 2. 2 to 200 is for your private company. And for your public, you can say that it is going to be 7 is the minimum. A public company may have any number of members. So 7 to infinity, any number of members can be there. And not less than 7. So 7 is your minimum and it can be anything, 1 lakh or 2 lakh or anything it can be. A private company can also be formed by one person, known as one person company. So you might have heard this in your accountancy. There is one person company. So only one person will be the member of the company. You can say they can also get into proprietorship, but if they want to comply with company provisions and if they are interested to form a company, they also have an option to become one person company. Okay. Duration of existence. Unless there is a contract to the contrary, death, retirement, or insolvency of the partner results in dissolution of the firm. Unless they have an agreement, the death of the partners, like if all the partners die, or if there is retirement of any of the partners, or the partners become insolvent, they don't have the money to repay the debt. That time only the firm will come into existence. Like that time it will cease to be existing. And a company enjoys a perpetual succession. Even if the members of the company die, the company is still going to continue. If the directors die, still the company is going to continue. Is the distinction between company and partnership firm clear to you people?
Yes, ma'am.
Yes, ma'am.
Everyone? Okay, only three are there in the class. Yes, let's go ahead. Partnership versus club. Okay, in case you need a break, please tell me. Do you need a break right now, or you want to continue like till we do the partnership and joint HUF or in a club also? How you say?
No, ma'am.
No break, right? We can continue. Give me 1 second. There is no chat. Gopika said okay. Lakshita has said okay. And who unmuted and said? Like all three of you don't have a problem. We can continue, right? Okay, let's go ahead. Let me check the status of the others, why they have left. Give me 1 second.
Ma'am, 5 minutes break, ma'am.
5 minutes break. Okay, take 5 minutes break. It's 11:44. We'll resume at 11:50. You can keep the meeting on if you want. Partnership versus club. And in partnership, we have understood that it is an association of person for earning profit from a business carried on by all or any of them acting for all. So here our major motive is to earn the profit. Whereas, well, it is the case of club, the objective is not to earn the profit, but of promoting some beneficial purposes such as improvement of health or providing recreation for the members. So here clubs are formed for improving your health, for doing some social work. That time you can say that clubs are formed. But in partnership, the business is carried on to get the profits, and one person may act for all or all of them can act for the firm. Relationship. Person forming a partnership are called partners, and a partner is an agent of other partners. Here they are called as members. People who are forming a club are called members. Member of club is not the agent of other members. He is not the agent of other members. He is not going to act on behalf of other members. He is just going to be a member of it. Interest in property. Partner has interest in the property of the firm. Member of club has no interest in the property of the club. So if a club is having a property, the partner is entitled only to the benefits. Like a member is entitled only for the benefits of it. Whatever money he has invested, whatever returns are being fetched by the club, that is the interest. But the property will not belong to the members. Dissolution. A change in the partners of the firm affect its existence. If the partner has died or if the partner takes retirement, that time dissolution may come up. A change in the membership of a club does not affect its existence. If the members are not the members of that club anymore, they leave the membership, that does not affect the working of the club. Club is still going to continue. Okay, clear this one? Should we go ahead?
Yes, ma'am.
Yes, ma'am.
Partnership versus HUF, Hindu undivided family. Mode of creation, partnership is created necessarily by agreement. In HUF, right in the joint family is created by status, means from the birth. Like when a child is born, that person, that child becomes the member of the HUF. They get the right to be member of that HUF. Death of a partner ordinarily leads to dissolution of partnership. If one or two of the partners die of a partnership firm, this may lead to dissolution. But if the death is there of a member of HUF, that does not give rise to dissolution of family business. Family business is going to still continue. If the grandfather dies, the sons will take forward the business. Management, all the partners are equally entitled to take part in the partnership firm. All the partners have equal rights to take part in the partnership firm. The right of management of joint family business generally vests in the karta, the governing male member or female member of the family. The head of the family, the male member who is the head of the family, or the female member who is head of the family, senior most member, becomes the karta of the family business. Okay, let's go ahead. HUF, they have given us some description. Amendment in the Hindu Succession Act 2005 entitled all adult members, Hindu males and females, to become co-partners in the HUF. Co-partner means the members of the HUF. If one is the karta, the other people of it are co-partners, right? C1, C2, C3, co-partners. Suppose if there is a person aged 60 years, so he'll be the karta of the family business, and he has two sons and a daughter. So this will be co-partner 1, co-partner 2, and co-partner 3. If they have a wife and they have children, two children, so they are also going to become the co-partners, son and daughter. Similar manner, wife, son, and she has another son. So this is how the things will. Okay. If the daughter is there, their members will not be included. His husband, daughter's husband, her husband will not be included. Her children will not be included in this HUF. They will become members of the other HUF where her husband is co-partner. Okay. They now enjoy equal rights of inheritance due to this amendment. So all the Hindu male and female all the adult members become the co-partners. On 1st February 2016, Justice Najmi Waziri gave a landmark judgment which allowed the eldest female co-partners of HUF to become a karta. If this person, 60 years, is a female, right? This is a female. The male is not in existence. The male has died. So she can also become the karta. From 2016, under the judgment given by Najmi Waziri, landmark case, that time we can say that the female co-partner can also become a karta. Okay? Not very much relevant for your examination, just you need to know about it. Authority to bind. Every partner can, by his act, bind the firm. Anything the partner does, he buys the goods. A buys the goods. So the firm has to pay for it. Karta or the manager has the authority to contract for the family business and other members in the family. Karta is the person who is going to manage the business, and he is going to act as the authority for taking all the family business decisions. Then we have liability. In a partnership, the liability of partners is unlimited. In an HUF, only the liability of Karta is unlimited. The other co-partner are liable only to the extent of their share in the profit of family business. So only Karta has the unlimited liability. Right? Others, they have limited liability. Co-partners have limited liability. Okay? Calling for accounts of closure. On closure, a partner can bring a suit against the firm for accounts provided he also seeks. Sorry. A partner can bring a suit against the firm for accounts provided he also seeks the dissolution of the firm. If a partner does not want the firm to continue, he may say that please bring all the documents and we need to close the firm. On a separation of joint family, a member is not entitled to ask for accounts of the family business. When the family business is separated, he cannot ask for the books of accounts of the business. If you want to become separate person from this HUF, you can just leave the HUF and go. A partnership is governed by the Indian Partnership Act 1932. HUF is covered by the Hindu law. Minor capacity. In a partnership, a minor cannot become a partner, though he can be admitted to the benefits of the firm only with consent of all the partners. If a minor is there, he can become a partner only for profits. Minor can be a partner only for profits. Here from birth, that member becomes the child becomes the member of the HUF. So here that case will not be there. In Hindu undivided family business, minor becomes a member of the ancestral business by the incidence of birth. From the time he is born, he becomes the co-partner. He does not have to wait for attaining majority. He does not have to wait for becoming 18 to become the member of the HUF. From the day he was born, he or she was born, becomes the member of the HUF. A firm subject to a contract between the partners gets dissolved by death or insolvency of partner. So, a firm will not continue if it is written in the contract that on death of any partner, firm will cease to exist. If it is written, firm will come to an end on death of one partner, it is going to end. HUF has continued till it is divided. Status of joint Hindu family is not thereby affected by death of any member. So if any member of the HUF dies, business won't stop. Joint Hindu family business will continue. And if it is that the joint Hindu family members want separation, they want to get divided, that time you can say the business will come to an number of members. In case of partnership, number of members should not exceed 50. Members of HUF who carry on a business may be unlimited number. So a family of 50 can also become an HUF. A family of 700 can also become an HUF. Share in the business. In a partnership, each partner has a defined share by virtue of an agreement between the partners. So they have an agreement where they'll be mentioning their profit sharing ratio. In HUF, no co-partner has definite share. His interest is a fluctuating one. It is capable of being enlarged by death in the family, diminished by births. So here there is no specific share of profit. It is just a floating share. Any amount you want to withdraw as a profit, you can withdraw from your partnership business. HUF business. Okay. Is partnership versus HUF clear to you people? They may ask you this as a question.
Yes, ma'am.
Should we go ahead? Okay, let's go ahead. Partnership versus co-ownership. Now, partnership versus co-ownership or joint ownership. Relation which subsists between person who own property jointly or in common. So people who are having common property or property in common possession, they will be considered as having co-ownership. Okay. Now, basis of difference. Formation partnership always arises out of a contract, express or implied. Co-ownership may arise either by agreement or by operation law, such as inheritance. Now, one property is there, right? Property is there. It has been distributed by father in the name of A and B, their sons. So here by inheritance, by operation of law, this property has come into co-ownership of two people. Implied agency, a partner is the agent of other partners. A co-owner is not the agent of other co-owners. Here there is no agency business. Only partnership has the agency business. Not doing some agency work, but they have a mutual agency between them, mutual agreement between them. There is community of interest, which means that the profits and losses must have to be shared. Co-ownership does not necessarily involve sharing of profit and losses. In co-ownership, if two people are having a land, whenever the land is sold, they will get the equal amount. Here, the sharing of profit is not mentioned. Transfer of interest. A share in the partnership is transferred only by the consent of other parties. Co-owner may transfer his interest or rights in the property without the consent of other owners. if the property belong to A and B, and B wants to give it to in the name of wife C. So he can just do it. He can go and make an agreement in the name of wife C, and he can say that this property now belongs to A and C, not A and B. Now A and C will be the owners. But in partnership firm, you have to take the permission from all the partners. Now, partnership versus association. Partnership means and involves setting up relation of agency between two or more persons who have entered into a business for gains with the intention to share the profits of business. Partnership comes into existence when they have agreed between there is an agreement, there is an agency between two people that they are going to enter into a business and share the profits of that business. Association. Association evolves out of social cause, and there is no necessarily motive to earn and share the profits. There is no motive to share the profits. Intention is not to enter into a business or a gain. They do not they are not intending to make a profit. They are not intending to do business. It can be of anything. Two people come together for a project to happen, so that project is also normal thing. That is also an association. That is not considered as partnership. Example: partnership to run a business and earn profit thereon. Member of charitable society or religious association or any improvement scheme or building corporation or a mutual insurance society or a trade protection association. So anyone who wants to protect the trade and commerce in the society. We have seen that in your area also you might see there is a trade area. So for protecting the rights of that people, association is created. Mutual insurance society is created, or a building corporation will be created. So all these are associations. Okay, let's go ahead. One second. But when the voice was not audible, did you understand the concept? Like you heard the concept or understood or not? You want me to repeat?
Yes,
I can repeat. Now, this was how the partnership differs from other types of association, joint stock company, then your normal association, joint stock company, co-ownership, etc. Now we'll be seeing kinds of partnership, how the partnership types are there. Some are partnership at will. People agree and get into a partnership. Then we will be seeing partnership for a fixed period. People are entering into a construction partnership for 5 years. They'll do the project in 5 years. So that is a fixed period. Then with regard to business, they are getting into particular partnership. They are doing the business of only footwear trading of footwear. So that is a particular. General partnership, they can do any type of activities they want. They can manufacture the footwear, they can sell the footwear. That is a general partnership. If they want, they can also start with the clothing. So that is a general partnership. Let's see each of one of them. Partnership at will, according to section 7 of the Act, partnership at will is particular partnership when no fixed period has been agreed upon the duration of partnership. There is no provision made as to determination of partnership. There is no provision made till how long this partnership is going to like work and what are the terms, etc. When there is nothing given about duration till when it is going to continue, that time you can say partnership is done at will. These two conditions must be satisfied before a partnership can be regarded as partnership at will. But when there is agreement between the partners either for duration of the partnership, now can you hear me?
Yes, ma'am.
Yes.
Okay, so these two conditions are to be satisfied for partnership to be regarded as partnership at will. But if they have given a duration of partnership, that time partnership cannot be said to be at will. This is not partnership at will, that will become a partnership at fixed duration. Now, see, what our law language does is they will mention that partnership is something that you determine, or like there is no fixed period given. That is partnership at will. Now, to contradict this, what they will say, partnership is not at will when the fixed period is not. So, that point which should have been included over here, partnership for a fixed period, will be again mentioned as a negation over here. So it is something like, if you remember these two major points, no fixed period is there and there is no provision made as to determination of partnership. These 2 points also you mentioned, that is enough. Where a partnership entered into a fixed term is continued after the expiry of such term, it is to be treated as having becoming partnership at will. Now what happened? They agreed the partnership will be continuing for 10 years. If this 10 years partnership is now going to continue again for 5 more years. They have not written it anywhere that it is going to continue for 5 more years. Still, they work on it and continue it further after the expiry. That time you can say partnership it as is at will. A partnership at will may be dissolved by any partner by giving notice in writing to all the partners of his intention to dissolve the same. If the partner wants to dissolve the partnership, he can do it in the partnership of will. If there is partnership at will, you can give a notice and all the partners will get into dissolution process. Okay. Next is partnership for a fixed period, where a provision is made by a contract for duration of partnership. Partnership is called partnership for a fixed period. It is a partnership created for a particular period of time. For 5 years, 10 years, you can create a partnership. Such a partnership comes into existence. Okay, again, comes to an end on the expiry of the fixed period. When the fixed period ends, the partnership will also come to an end. A partnership may be organized for the prosecution of single adventure. As I told you, only trading of business, only construction business. That is a particular single adventure, as well as conduct of a continuous business. I told you, like construction is going to take 5 years. So that is some continuous business. Single adventure as well as the conduct of a continuous business. Where a person becomes a partner with another person in any particular adventure or undertaking the partnership is called particular partnership. When one wants to do a business for a particular adventure, for doing one thing only, that time you can say this business is a particular partnership. A partnership constituted for a single adventure or undertaking is subject to any agreement dissolved by the completion of the adventure or undertaking. When the completion is done of the adventure or the undertaking, that time you can say that particular partnership comes to an end. When the construction is done, that time your partnership will come to an end. Where a partnership is constituted with respect to business in general, it is called general partnership. Two partners agree to sell the products. Any product can be sold. Any duration of years can be the partnership can be in function. So that time you can say it is a general partnership. General partnership is different from particular partnership. In case of particular partnership, liability of partner extends only to do a particular adventure or undertaking, but it is not so in case of general partnership. General partnership, it is different from limited liability partnership. So if some people are agreeing for the construction business, right? Construction business, and while they were in construction business, a fire catches up in the site where it was construction was being done. So they will be responsible for getting the fire extinguished, and if there is any loss for that, they'll be agreeing. But with construction business, they made a cafe, right? They made a restaurant or a cafe. For this type of business, they won't be responsible because that was not written in the partnership. For this, the partners are not liable to pay the money. If one of the partner made a food area, a restaurant over there, a cafe over there, other partners will not be liable because it was not written in that particular partnership agreement. Are these four types of partnership, kinds of partnership, clear to you all?
Yes, ma'am.
Yes, ma'am.
Okay, let's go ahead. Partnership deed. Partnership is the result of an agreement. No particular formalities are required for agreement of partnership. It may be in writing or formed verbally. So it is an agreement. Partnership is an agreement. And no particular formalities are required for an agreement of partnership. If you talk to people and get into a partnership, that also works. It can be written or it can be verbal. But it is desirable to have the partnership agreement in writing to avoid future disputes. To avoid the future disputes, many people get into a written partnership agreement. Document in writing containing various terms and conditions of the relationship of partners to each other is called as partnership. A particular agreement which consists of the terms and conditions of the partnership, what is the relation of partners, how they are going to share the profits, all this is included in an agreement, and that document is called as partnership deed. It should be drafted with care and be stamped according to the provisions of the Stamp Act 1899. It needs to be stamped by the authority of Stamp Act 1899. When the partnership comprises immovable property, the instruments of partnership must be in writing. If you are agreeing for a construction business, so it should be in writing. When you are making something of the immovable property, or if you are agreeing for a shopping complex, like you have made a shopping complex in partnership and the revenue will be generated between the two partners, that time also when immovable property is involved, you have to make the partnership deed in writing, get it stamped and registered under the Registration Act, under the Partnership Act 1932. Partnership deed may contain the following information: name of partnership firm, name of all partners, name and place of business of the firm. Then your profit sharing ratio will be asked, date of commencement of partnership, duration of the partnership firm, capital contribution, how much the partners will be contributing. All these things will be mentioned. PSR ratio, profit sharing ratio. Admission and retirement of partner, when that happens, what are the terms and conditions. Rate of interest on capital, drawings and loans. So what is the rate of interest on capital allowed? Accounts question I'm asking you. What is the rate of interest on capital allowed to the partners? %12 or 6%? On drawings, how much is allowed? Okay, 12% is correct. So you remember something about accounts. Provision for settlement of accounts in case of dissolution. So how the accounts will be settled when the firm will be dissolved, what is the share to be given, how the goodwill will be recognized, all these things are to be written in your partnership deed. What is the salary to be paid, how much commission will be paid to the partners, what other than this any amounts are to be given to partners, any plant or machinery properties to be given to the partners, all things are going to be mentioned in your partnership firm. Partnership deed. Provision for expulsion of a partner in case of gross breach or of duty or fraud. If the partner does something wrong, can we like eliminate him from the partnership? Can we expel the partner from the partnership? All these provisions also need to be mentioned in your partnership deed. A partnership firm may add or delete any provision according to needs of firm. You can make the amendments in the partnership deed and you can change any of the documents you want, like any of the provisions you want to be changed. Is partnership deed clear to you all?
Yes, ma'am.
Yes. Okay. Types of partner. Yeah. So the types of partners are active, ostensible, nominal, sub-partner, outgoing partner, sleeping or dormant partner, partner in profit only. Who are partner in profit only?
He will share profit only.
Minor. Minor can be considered as partner in profit only.
Yes, ma'am.
Incoming partner, the partner who is joining your firm now. Partner by holding out. All these types we'll be seeing now. Active or actual or ostensible partner. It is a person who has become a partner by agreement, who actively participates in the conduct of the partnership. A and B are the partners, and A is the one who manages work, manages firm. So he is going to become the active partner. Okay. He acts as an agent of other partners or for all acts done in the ordinary course of business. In the event of his retirement, he must give a public notice in order to absolve himself of liabilities for acts of other partners done after his retirement. Now, when this active partner wants to resign, he has to give a notice. And he will give a notice and say, I am not going to be a partner anymore. And any of the activities done by other partners after my retirement, I am not bound to pay any money. Okay. So if after A retires and C joins, B and C do any of the work, A is not liable after retirement. Till retirement only he was liable. Next is your sleeping or dormant partner. They share profits and losses and are liable to the third parties for all acts of the firm. They are liable for doing all the activities of the firm, whatever they do, and other people, they just invest their money and they do not participate in the everyday work. They are, however, not required to give a public notice of the retirement. If they want to retire, they don't have to give a public notice. They can easily retire by informing all the other partners. Sleeping partner, it is a partner who is partner by agreement and who does not actively take part. Sorry. Is wrong with this one. He is a partner only by agreement and who does not actively take part in the conduct of the partnership business. So this sleeping partner will not be taking part in the conduct of the business. This partner will not make any decisions, will not do any work of the partnership business. That is called your sleeping or dormant partner. Okay. Next is your nominal partner who has just given the name. Now, if we consider Amitabh Bachchan giving the name in a partnership form, will he go and work in the partnership form? No, he is just mentioning his name. I am partnering with this company. A person who lends his name to the firm without having any real interest is called as nominal partner. He is not entitled to share of profit of the firm, neither he invests in the firm, nor takes part in the conduct of the business. He is, however, liable to third parties for all acts of the firm. So he is not investing money, he will not get any profit. He is just giving the name, okay, I am associated with this partnership firm. But if something goes wrong and the firm has to pay the money, this partner, nominal partner, will also have to pay the money. Lends his name to the firm without having any real interest, not entitled to share of profit. Does not take part in the conduct of the business, liable to third party for all acts of the firm. If firm has become insolvent and 10 CR is to be paid, firm has only 8 CR. For this 2 CR, nominal partner will also have to pay. Then we have your partner in profits only. A partner who is entitled to share the profits only without being liable to loss is known as partner of profits only, and also liable to third parties for acts of profits only. So if some profit he has received and he has to give it to third party, this partner is liable. No loss will be suffered, but for profits he is liable. Incoming partner, a partner who is admitted as a partner into an already existing firm with the consent of all existing partners is called as incoming partner. Such a partner is not liable for any of the act of firm done before admission. So if, let's take the example that they have given. A joined as the partner on 10th of September, right? A joined on 10th of September 2021 in the firm MNQ. Now, if there, which was existing from 10th July 2007. This firm came into existence on 10th July 2017. From 10th July 2017 to 9th September 21, whatever liability will be there, profit will be there, A is not entitled to it. A is not going to be a part of it. Okay, A is not going to get any benefits. He is not liable to pay any of the liabilities. Mr. A will not be liable for any acts of the firm done before his joining date, that is 10 September. So before 10 September, that's your 9 September 21. Till that time, he is not liable for anything. Next is your outgoing partner. A partner who leaves a firm in which the rest of the partners continue is called as retiring or outgoing partner. A person who is going out of the firm is retiring from the firm. Other partners are continuing. So that is called as retiring or outgoing partner. Such a partner remains liable to third parties of the firm until public notice is given of his retirement. Now, here on 10th of September, let's consider he gives a notice. So, until he gives the notice, he will be liable from 10th of 17 to 9/9/21. He will be liable. A will be liable if he is an outgoing partner. I didn't take a different example. I just explained you in this one. Second. Partner by holding out. Partnership by holding out is known as partnership by estoppel, where a man holds himself out as a partner or allows other to do it when he to do it when he stopped from denying the character he has assumed upon the faith on which he may presume to have acted. Now, what happens? One person acts that I am the partner of this firm, and that person, when he is acting as the partner of the firm, let's suppose, you might be aware of MS Dhoni, right? MS Dhoni says, I am the partner of Coca-Cola India, right? He says, I am the partner of Coca-Cola India. Actually, he was not the partner of Coca-Cola India. Now, what happens? Coca-Cola India is seeing that after Mahendra Singh Dhoni has said that I am the partner of Coca-Cola India, the sales have increased. Now, what Coca-Cola India will say? You continue to be the partner of the firm by name, by holding out, by saying that I am the partner. You have to continue as the partner of the firm because it is helping the company. Okay. When a person represents himself or knowingly permits himself, when he is representing himself as partner or knowingly permits himself, if Coca-Cola India comes up with an ad and says Dhoni is our partner, Dhoni didn't say, but Coca-Cola India said. So now that also he permits to be represented as partner in a firm where in fact he is not, but he is not a partner in that firm. Still he behaves like he is a partner in the firm. He is liable like a partner in the firm. He will have all the liabilities like that of a partner in the firm. He will have to pay for all the dues of the firm. He will have unlimited liability. To anyone who on faith of such representation has given credit to the firm. Now, SBI Bank got to know that Dhoni is the partner of Coca-Cola India, and Coca-Cola India had approached SBI for 200 crore rupees 200 crore loan. Now, what they do is SBI feels Dhoni is the partner of Coca-Cola India, so Coca-Cola will make great sales. Now, I can give them the loan. If this person, SBI, has believed that Dhoni is the partner of India, and that is why they have kept the faith on that representation and given credit, given loan to the Coca-Cola India, then for that loan also Dhoni is payable. Dhoni has to pay for that money. Okay. So SBI can recover the money from MS Dhoni also. A person may himself, by his words or conduct, have induced others to believe that he is a partner, or he may have allowed others to represent him as a partner. Result in both cases are identical. Till here, is everything clear to you people?
Yes, ma'am.
Okay, let's see this example that will help you for partner with partner by holding. X and Y are partners in a partnership firm. X introduced a manager as his partner to Z. Now, X and Y are the partners. X introduced whom? A as a manager, who was actually a manager, as his partner, to whom he introduced to Mr. Z. Now, this has also become partner by holding out. Partner by holding out. A remained silent. A did not say anything. He said, okay, I am the partner you are saying, I'll become the partner. Z, a trader, believing A is the partner, supplied 100 TV sets to the firm on credit. Now, Z gave 100 TV sets to whom? XY and company. Right? To XY and company. This partnership firm, he gave 100 TV sets. After expiry of credit period, Z did not get the amount of TV sets sold to the partnership firm. Z filed a suit against X and A for the recovery of the price. Now, what happened? Z filed a case. He filed a case. Now, change the color. Now, this Z has filed the case against X and A, the partners of the firm. However, in this case, A, the manager, is also liable for price because he becomes a partner by holding out. He did not deny the fact that I am not the partner. He also agreed to the thing, okay, you call me partner, I am the partner of that firm. So when he has not denied, that time you can't say that this person is not your partner. And that person, Mr. A, will also be liable for the payment of your dues. Okay. It is only the person to whom the representation has been made. Okay, 1 second. It is only to the person to whom the representation has been made and who has acted thereon that has the right to enforce liability arising out of holding out. Now, the person whom the representation has been made or who has acted thereon. Now, Z was the person to whom the representation was made. Z was shown that A is the partner. Now, only he can enforce the liability. No other person. If M comes up, M does not know that A is the partner. So he can't force A to pay the liability. Only Z knows, so Z can only enforce. You must also note that for the purpose of fixing liability on a person who has by representation led another to act, it is not necessary to show that he was actuated by the fraudulent intention. You can say, like, by mistake I said A is the partner. I didn't want to do it by fraud. Even though if you have done fraud, you don't have to admit that I have done a fraud. You can just say it happened by mistake. It is not necessary that he was actuated by fraud intention. He does not have to actually say that I had a fraudulent intention. I wanted the 100 TV sets immediately. That is why I told A is the part. Or else I wouldn't have got the TV sets. So you don't have to be true over there, honest over there. The rule given in section 28 is also applicable to a former partner who has retired from the firm without giving proper public notice of his retirement. In such a case, a person who even subsequent to the retirement gives credit to the firm on belief that he was a partner will be entitled to hold him liable. Now, even though if some partner has resigned or if some person was acting as a partner by estoppel or partner by holding out and that person has resigned, still that person will be liable if he has not given a proper public notice. Okay, clear? Let's see this example. A partnership firm consisting of P, Q, R, and S. S retires from the firm without giving public notice and his name continues to be used on letterheads. Hence, S is liable by partner of holding as a partner by holding out to the creditors who have lent on the faith of him being a partner. Now, what happens is when a partnership firm is there or whenever a business is there, they have a letterhead, right? The name of the business is there. If you visit a doctor also, you see the name of the hospital is given. In this letterhead, it was written PQRS and company. So there was not written that now we are only PQR. If S has retired also and he has not given public notice means you have to issue in the newspaper. Not given public notice or not filed a public notice with the partnership commission, that time you can say that this person is still liable because on the letterhead his name is written and he has to rely on the faith that this person is going to be the partner and he has to pay for any of the losses until he gives out the public notice. Okay, are we clear till here?
Yes, ma'am.
Yes, ma'am.
I guess this was the end of the chapter. Let me see one second. It's not loading up for me. Yeah, that was the end of this unit number 1, right? So you want me to resume the unit number 2 right away or you need some break and then we should rejoin like half an hour or something you need?
Break, ma'am.
Break, okay. So should we resume at 1 or 1:30 you want, how you want? Because now you people have time, right? So we can cover up the entire syllabus of partnership if you want. I am not able to understand what you have typed, Lakshida. Is it something in Tamil? I am not aware of Tamil. Okay, yes. Tell me the break timing till when you want it. Like 1 or 1:30 you want, how you should be resuming 1:15.
1:30, ma'am.
1:30, you need an hour's break. Gopika is saying 1. Others are saying 1:30. Okay, what we can do is we can take a break till 1:30, like 1:30. Lakshita is also saying 1:30. Let's take a break till 1:30. You can have a lunch, etc. And then we can resume with unit number. Okay. We'll resume with relation of partners. I guess that's a huge unit. So we can just cover the entire 2 units today and we can go ahead then. Right. So 1:30 we'll resume our class. 1:30 we'll start with unit number 2. Okay. You can join from the same link. I'll put the message in the group at 1:30 that we are starting the lecture. When we have the case law decision class. Okay, so once we are like you have your test on 26th, right? 26
Yes,
is
ma'am.
the test. So by then I am targeting to complete your partnership and companies. So we'll be left with LLP and Sale of Goods Act. So when the paper comes in, you will be able to attempt. And this paper, I'll try to make it more of the questions will be direct questions. Instead of case study, I'll include only few case studies. The others will be your direct questions. Okay, some of them will be case studies that will be based on the knowledge that you have acquired in the units that you have learned. Okay, clear everyone? Let's end the class now and we'll resume at 1:30.